It is just before 9 p.m. here in New York, the end of a nearly 12-hour day for jurors in the first of former president's 4 criminal trials. They'll get the case tomorrow, with it a job that no jury has ever had before, deciding whether or not to convict a former president of the United States and current candidate for the office again of as many as 34 felonies. Today was the final chance for both sides to persuade them. We're talking about it tonight. Joining the panel, retired New York City criminal judge George Grasso and jury consultant Alan Turkheimer. Judge Grasso, it is great to have you with all your experience here. What did you make of closing arguments tonight? I mean, 5 hours, 2.5, 3 hours? Is that?
Well, it was a long day. For the most part, I found it. I was totally zoned in. It went pretty quick. I felt towards the last hour or so that Mr. Steinglass could have moved it along. I didn't know if we needed like 6 book excerpts.
Your choice.
Your choice excerpts. I think less would have been a little more with some of that. But I think look, on the defense end, I think Todd Blanchard was. I heard the word meandering.
Yeah.
I certainly subscribe to that.
Mm-hmm.
I think he made a real legal and tactical mistake by diving into People's Exhibits 35 and 36, the Weisselberg notes. I think they are the smoking gun evidence, and I think he dove into a minefield without a plan to get through it.
Do you think he should not have even brought those up?
If anything, I wouldn't. He led with it.
Right.
That's not those documents are not his strong suit. And I anticipated, and then I saw Steinglass just went to town. Mm-hmm. He got an A+ on that. He had both documents up. You've got Weisselberg's handwriting on the documents, laying out the scheme, the $420,000. You got McConney on a separate document, number 36, with his handwriting, parroting the same scheme. And just so we have a trifecta, on 35, you got Cohen's handwriting too.
And one thing that Steinglass seemed to drill in on was he seemed to be making fun of Todd Blanche. That was kind of the tone that he tried to adopt the whole time. But he was saying this idea that Todd Blanche is arguing that because these documents exist, show that no crime was committed here, that no documents were falsified because you can see them. He was saying there'd never be a business falsification case ever because they would just destroy them, and if they existed, they would say, well, it's not a crime. Yeah. And that was something he looked to the committee and said, you almost have to the jury and said, you almost have to laugh at the way Mr. Blanche explained it to you. You've been in there every single day. You sit in the same seat for people who don't know. Everyone else has to fight for a seat. He has his own same seat, which I'm obsessed with. But I wonder what you make of how that sat with the jury as they're watching this.
You mean what Blanche did with the
and how Steinglass kind of turned it around.
Oh, I think putting it all together, I think if it's a tennis match, I mean, Steinglass just nailed him. He put it over the net and killed it. And I think the jury, this is a smart jury. I mean, we all look at the same jury, we see the same jury. Norman and I were there for the questioning of the jurors. These are people who want to be there. They could have just raised their hand if they didn't want to be there. They would have left. They've been through the whole process. Today was day 21. They're clearly paying attention. This was not over their head.
Alan,
they got this.
Alan, you're a jury consultant. There's a lot of talk about the length of the closing arguments. Have you ever come across jurors who were so annoyed about the duration that it actually impacted their votes?
I don't think it impacted their votes, and I think since both sides went excessively long with their closings, I think it's probably a draw in terms of which side seemed to be a little more tedious, a little more in the weeds, a little more on extraneous information that they didn't need. So I think each side, they did okay, they did a good job, but they missed delivering stellar closings. Now the defense, I think, did what it had to. It raised some questions about fraudulent intent on the part of Trump regarding the invoices surrounding the payments, but they were a little gratuitous with some cheap shots at Michael Cohen and a little gimmicky. Prosecution, I think, was a little more streamlined. They gave a timeline, laid out the elements and the actual verdict questions jurors are going to have, but the state also took a long time. So at this point, it's about deliberation advocacy, and I would guess that of the 12 jurors, maybe 4 of them are pretty firmly convinced of guilt or innocence, and then another 4 are leaning in one direction or the other, and then 4 are waiting for deliberations to make a decision.
And Judge, if a jury can't reach a decision, if we're deadlock, there's something called an Allen charge that the judge can give to the what is that?
It's basically, it's kind of like looking at them. You took an oath. I believe in you. You believe in me. We can do this.
This is the nice way it's done.
Is this like putting the thumb screws?
No, Rashawn is going to do it nicely.
Yeah.
But that's where.
So wait, you can do the Allen charge nice, or you can do it rough. Is
Well,
that what you're
I
saying?
think what may very well get us to the verdict here is I think Rashawn has a ton of goodwill with this jury. A ton of goodwill with this jury. I think if for no other reason, they're not going to want to disappoint him.
He's been protecting the jury in the sense of like kind to them. We'd like to go along, but if any one of you has any issue, we won't do it. If they didn't go along one day because the jury couldn't do it.
100%. So he's got a lot of goodwill in the bank
Judge
there.
Grasso, and since you have the experience here, could you tell us what a missing witness charge is? Because that is in the realm of possibilities. I don't think Judge Rashawn has ruled publicly whether he's going to give a missing witness charge. But regarding Weisselberg, just tell them what that means. Because that's a huge win for the defense if he gives a missing.
Here's why I don't think they're going to give it. Because
Could you just tell us what it is
let me
first?
tell you, it's got to be a witness that's peculiarly under the control of the people. So what that would typically mean, someone's locked up, you're the defense attorney,
locked up.
you can't, but they could get him. Mershon called that bluff.
But the defense said he would take the fifth if we call him, but the prosecutor could give him
Well,
immunity.
let me answer the question. I was in the courtroom, Norman was in the courtroom, when that issue came up. And Mershon said, because it came up, because I actually thought that the DA was playing a little bit of a game with the exit agreement with the $2 million, that they wanted to be able to get that in evidence. And then Mershon said, well, did you try and get him yet? He asked them that question. And then Steinglass was kind of hemming and hawing with that a little bit. So Mershon says, okay, what about we bring him in, we bring Weisselberg in, outside the presence of the jury, and we question him. Blanche, in a heartbeat, jumped up. He's not on the witness list, Judge. We're not ready for him. It was so obvious. He was objecting. And then Mershon, and the way Mershon does it, he looked at him and he said, oh, so this is the first time you're considering that Alan Weisselberg might be a witness in this case? After Mershon did that, and it was obvious he could have brought him in if he wanted, he's not interested in bringing him in to try and say this is peculiarly under the control of the government. So you get that charge author. That's why I don't see it.
Yeah, it's in that instance, neither side wanted Weisselberg to come in. Not to mention the fact that even if Weisselberg were to testify, it's not clear that he would be a witness for the prosecution. That is not clear at all.
Did the defense harp on it in summation? Did the defense harp on it?
No, because they don't want. They don't want him to come in either.
No, but in summation, it's too late. I'd say, where's Weisselberg? There's his handwriting. Here's Exhibit 35. Judge Grasso's really upset about this. It's all his handwriting. Where is he, folks? They have the burden.
They did that with some other witnesses. They made that point, right? Blanche basically made that point on a number of occasions, saying, the prosecution, they didn't bring in any lawmakers to talk about the impact of the Access Hollywood tape. They didn't bring in that person. They didn't bring in this person. They did it kind of obliquely, but they did not do it for Weisselberg, and I thought that was extremely notable.
The most ridiculous example of this was when the defense tasked the prosecution with not bringing in Don Jr. and Eric.
Right,
it was another one
because
of those
they were also people who
that
signed the
misfired.
checks.
And Arthur, I can tell you, we're not getting a missing witness instruction because we sat through a lengthy charging conference. It was not discussed. It's not in any of the submissions. Not happening.
So they didn't even. So okay, I
They
got
didn't
you.
request it.
We have like the
Credit.
ultimate two trial groupies right here. I love it. You've been to like every motion. That's
It's even
amazing.
worse afterwards. We stand in the hallway arguing about it like it's Shakespeare
We do it again on Sunday.
for hours.
The one thing Trump keeps talking about and he's complaining about tonight is that he can't use the reliance on counsel argument, which was something that was settled, over 6 weeks ago when they were first making this call of saying he can't say that he was relying on legal advice of Michael Cohen when Michael Cohen told him the agreement was airtight and bulletproof. And now he is increasingly angry about that and keeps bringing it up, even though the judge made clear, during the jury instruction debate that I assume both of you were in last week, that was long gone. That was never even going to be an option here.
Well, it's such a bogus issue because David Pecker has already testified that he didn't provide the counsel with pertinent information. He just, here, take a look at this. None of the background information, none of the things going on behind the scenes with campaign and money that not being reported. It's just like, here, counsel, look at it in a half hour, yeah, this is good. Trump knows that. Trump's lawyers know that. And, they just want to try and muddy the waters with it. But it wasn't like they got a legitimate opinion from their general counsel. I was general counsel for the police department for 5 years. You're going to ask me for an opinion, submit all the relevant pertinent information. Don't hold back information and then take my Deputy Commissioner Grasso's opinion and then hold that up as a legal opinion, because it's not. And that's exactly the game they're trying to pull here.
Judge, if I could ask you, do you see any potential appellate issue with the way the DA has charged this case? For the first time in New York history, they've essentially imported a federal campaign finance violation into a state charge.
Norman and I have been talking about this ad nauseum. Yeah.
Shockingly. Well, I want to hear where the judge comes. I know where Norm comes out. I want to hear where you come out.
Well, it still is. I give the DA very high marks, absent 6 book excerpts, on their summation. But it's still a little tricky to figure out how I think as far as the falsified business records, I think it's almost slam dunk right now that they've got Trump pretty solid. I think that the summation for the DA buttoned up a lot of that. But connecting that now, what are we connecting it to? How are we now? There is the pain, it's being covered up. It was covered up the way it was covered up because it was an unreported campaign contribution. But how has that been imputed to Trump yet?
Right.
And what is the actual? I still have not seen the final charges to the jury. I'm going to be, as a real nerd on this, I'm going to be like zoning right in. I want to see where they're using willful, what they're going to be using for state of mind, and whatever they use, I think that this is definitely a potential.
Judge, to Ellie's point, a lot of appellate issues, a lot of cases that are overturned on the judge's charge to the jury.
Yeah.
Basically, you gave the rules of the game to the people deciding the game inaccurately, and you've been there every day.
Yeah.
For you to say after summations, prosecutors have done a great job, but it's a little willy-nilly on how they're going to get there.
I'm saying that because
Gives me pause about whether this case should have been brought at all.
Well, you know what? I disagree with you on that. We've had this conversation on your radio show.
Every day.
Every day. I think there was something rotten in Denmark there. And I think there's a mountain of evidence and I think that the Trump Tower conspiracy meeting, August of 2015, I think the defense summation fell really flat when they tried to say that David Pecker had no knowledge of what catch and kill because he didn't use the word. There's a 130,000, 150,000, 30,000. Let me finish. That was clearly clearly directed towards the campaign. At least to me, going there every day, you have to be kind of deaf, dumb, and blind not to see that.
But a minute ago, you said it's willy-nilly. A minute ago.
Well, I'm talking about.
They do it like this, like you're riding a bike. You're like, it's a little willy-nilly.
I'm talking about it in the context of what is the charge going to look like? How is the jury going to process it? And what is it going to look like on appeal? Because there is some new ground being made.
Last question. In all your years on the bench, over a decade, did you ever have a charge that it was the first time ever you created the charge? It didn't exist anywhere else? I can give you the answer. The answer is no.
Well, I never had a guy who ran for president who thought it was a good idea to get some friends together and get a lot of money together. We have something here that never happened before. These laws were never used the way they were used before because they were never, at least from what I've seen, abused the way they were abused by this particular defendant. Now, does that ultimately lead to a bulletproof verdict if they do choose to find him guilty? We'll have to see. But I think the evidence was there to bring the case. I think the evidence is there to convict. But we'll have to ultimately see if he's convicted, what the appellate
There you
division
go.
does.
With Judge Grasso.
We got to go. But I just wanted to ask you, you've looked in the eyes of a lot of jurors. Watching the juries, I'm sure you have. What do you make of how they have been paying attention?
They're paying attention. I'm taking notes, vigorously, and so I'm always into the notes. But then I just like randomly look up and scan, and these people are paying attention. They're serious. What do you think, Norman?
As smart and dedicated and focused a jury as I've ever seen in over 30 years, but never sitting above the courtroom wearing the robe.
Judge Grasso, wow, so great to have you. Thank you so much.
Pleasure is mine.
Alan
Thank you.
Turkheimer as well. Thank you so much. Appreciate it. Coming up next, John Berman's back